me introduce Cory a little bit. So he has been on the beYogi webinar series. Cory, correct me if I'm wrong, but I think it's number 4 now, right?
Yes, number 4 sounds about right.
Right. So we've done quite a few. We trust him fully to be our yoga law expert. So he is here again to answer some of your questions that you sent in to me today. So he's the founder and leading lawyer at Conscious Counsel. And now he has just started Law is Fun, which I'll let him tell you guys a little bit about. But he has also wrote the yoga law book and have served hundreds of clients in the health and fitness and yoga spaces all across the world, the majority of whom own or operate health studios, yoga studios. We're happy to have him back. So Cory, tell us a little bit about Law is Fun.
I'm happy to tell you about Law is Fun. And I also just want to say that it's so awesome to be back with beYogi. I remember, I think webinar number 3 that we did, or webinar number 2, one of the webinars, it was like, I was on this crazy trip and there was no Wi-Fi and I barely made it, but I made it. And yeah, and that's just like, when I think of all the things that I've done, I always remember that. But also just having worked with a lot of people from beYogi, I think it's always awesome. So I'm super grateful to be here. Law is Fun is a side venture that we've launched, which is basically automated, customized legal documents. It's different than Conscious Counsel, our law firm. What we saw was a lot of clients. I've always seen 2 different types of clients. One client who is looking for the relationship, who's looking for the ongoing support, wants to ask questions. Something comes up, they want to be working with a lawyer. And for them, working with the law firm makes more sense. But I also saw a lot of clients who are like, hey, look, I just want a document. I don't really care about talking to you or needing support or whatever. I'm good. So we came up with a website that's, operated by a separate company that's not legal services, but it's automated documents. So basically, you go to the website, you purchase whatever documents it is that you want, you answer some questions about your yoga business and what you do, and then within 2 days, we send you an automated link of the finalized document, ready to use, no support, no legal counsel, just giving the people exactly what they want. So we haven't even publicly launched it. I opened it today for the beYogi community, but it's very, very soft. It's very beta right now, but so far it's been really awesome. So making law fun again, right?
Love it. Yeah, we'll definitely keep you all updated on when the hard launch is, and we'll kind of give you some information on our follow-up, but just wanted to give you a little heads up with what's coming from Cory and Conscious Counsel and Law is Fun. So again, keep asking your questions into the chat. We'll get to them, but Cory is going to help us kind of start this webinar off with like a short 15-20 minute how not to get sued as a yoga instructor. So if you want to get started, Cory, take it away.
Yeah, I'm happy to. Thanks so much, Lizzie. And part of the reason why the title is Don't Get Sued, I've worked in the yoga industry, as a lawyer for yoga professionals for almost 5 years now. So I've been through a lot, and a lot of things have changed recently, which has obviously changed the landscape quite a bit of what's happening. And I'm happy to speak about those changes and how we can be a best practices. But it's also like, it's not really groundbreaking, the types of things that we have to do and the way that we have to think about law to make sure that we're protected. So really not getting sued is like, it's never been easier, I suppose, to not get sued. And that's part of the reason why I'm excited to share all of this information. Also, I made an online course called Don't Get Sued, Legal Essentials for Health and Wellness Professionals. That's awesome, Marina. Welcome. And so the reason why I made that online course is like this, just so everyone gets a little bit of insight into my life, which is not that exciting. But as a lawyer, all the time I'm, speaking to all these different yoga professionals all over the world. And all of them are coming to me and they all have basically the same questions, or they all want to understand the same basic things. And what they don't realize is like everyone really just has the same questions. So I made this online course, and the whole idea was me trying to like use the course as a platform to provide the answers for the questions that I most commonly hear. And before I get into, thanks so much for doing that, Lizzie. So why doesn't everyone who's here, if you don't mind, just throw your name in the chat, and where you're tuning in from. That would be really cool. Also, if you have a snack, if you're eating a snack, if you want to eat a snack, anything related to snack. I sort of just had lunch, but this is like a lovely juice that has beets and orange and apple in it. Lizzie, what are you rocking for snack?
I just actually finished a banana right before we came on, so healthy. And then I have my lemon water, just lemon juice and water, and half of a cold coffee.
It sounds like you're in great shape with all of those things. Hey, Marina. Hey, Beth. Feel free to share. Victoria, sunflower seeds and water. Look, basics. This is just like delicious, to the point. Get me my sunflower seeds, get me water, all of those things. So that's really cool. Okay, so how not to get sued or don't get sued. I'm going to chat about all that. And also, before I do, just one more reminder for anyone who's tuning in, whatever questions you got, this is the moment. I'm here. I'm happy. It's very unlikely you're going to ask me something that I haven't heard. I hope you have. I'm always pleasantly surprised. But whatever legal questions you have, we're not really reinventing the wheel here. It's just making, I want to be as great of a resource and helpful as possible for everyone. So there you have it. Okay, how not to get sued. The first thing that you have to realize is that if you're going to get sued, it's going to come from someone or somewhere. And so if we reverse engineer the whole process and we start from the end, the goal of what it is that we want to do is we want to have all of our relationships, our different commercial relationships, we want to have all of them organized in a way where within each relationship, we are communicating our expectations openly and honestly. And this is a law talk, and it's about not getting sued. And even these agreements that you have with people, it is possible, if you want to, that you can write these agreements yourself, although I wouldn't necessarily recommend that. But the reason why is the biggest reason why someone will get sued is there's been some misaligned expectation. This applies to our relationships in general in our life, but it also applies in law, that there's a misaligned expectation where someone was working with you, they thought they were getting X, or they thought that Y was going to happen. It didn't. And then as a result, they're upset. The way that they emotionally deal with it is try to resolve it legally and escalate it through the courts and to sue you, or that someone just gets injured. And we'll talk about waivers of liability in a second. But once you know that it's going to come, you're going to get sued from one of the relationships that you have, the goal really is just like, okay, cool. Well, probably the thing that I could do to protect myself in the best way possible would be to have all of these relationships documented and have everything in writing, all of the expectations, what I'm doing, what you can expect from me, when payments are made, when cancellations are made, how scheduling works, what my qualifications are, what I do, what I don't do, what is acceptable, what is unacceptable behavior, all of these things, and have them in writing and get someone to sign it, and you sign it yourself as well before you start. And the reason why that's probably the key to not getting sued is because when something is potentially elevating legally, the way that it actually works in law, it's not like something happens and the next day you're in court, right? It's a very, very long process. There are a lot of things that happen in between you being, something happening and actually it getting to court and you actually being sued. And in the interim, there's all of these opportunities to actually resolve the situation. So you can resolve the situation amicably. You can resolve it aggressively. Sometimes there's a settlement fee, sometimes there's not. But the most important thing in the process of what one actually goes through before getting sued is there's always something called a demand letter. So demand letter is always going to be like, either someone's upset with you and they've hired a lawyer and this lawyer is sending you a letter, or they're upset with you and they're sending you an email. And in that letter, they're going to say, hey, you made all these mistakes. You're such a terrible business owner or person, right? And maybe they'll call you names or whatever it is that they do. And because you made these mistakes, I suffered these damages. And as a result, you have to pay me, $14,000 for my emotional suffering and damages and all of this stuff, whatever it is. Now, the process of how the course of this complaint and resolution will go will mostly always be rooted to your first position. So if you're in a first position, someone has a complaint and you're able to produce a signed, legally binding agreement, which, negates the complaint, which shows that someone already, surrendered or waived their ability to sue you, their legal position from the start, maybe at the beginning it's 50-50, but because of the signed documents, their legal position, they're at 10%. And so for them to continue the entire process from a legal position of 10%, it basically means 9 out of 10 times you're going to lose. And it's going to cost a lot. It costs a lot of money to hire lawyers and fight through things, and takes a lot of time and energy. And so the best way that you can really not get sued is by having great legal agreements set up from the start. I'm just going to pause there for a second. Does anyone have any questions? Does anyone have any comments? Does anybody want to share anything on that whole concept of the best way to get sued is to have documents which communicate your expectations openly and honestly, and that, can be used as a tool to resolve anything should something come up?
Yeah, Cory, so we got definitely a couple questions about liability waivers, and we can touch on that. I did get a question from Laura, and I'm going to follow up, Laura, with this because I'll read the question. If I hold yoga and it's about yoga insurance versus kind of law, but if I hold yoga training in a home setting, if there's an accident, would I need special coverage on the homeowner's policy, or would beYogi cover this? I'll answer the insurance part of that, but Cory, I believe you could probably help with this even beyond insurance, right?
Yeah, so I'm happy to, and I would also love to hear your answer.
Yeah.
So that's a great question, Laura, and thank you for that. So basically, let's say you're running yoga teacher training out of your house as the example. You can have specific legal documents so long as it's specific to the things that you're doing and where you're doing it and what equipment you're using and all of these things and related to it. You could have someone sign a waiver of liability that covers the practice of yoga or yoga instruction from your personal home. That's total, you 100% can. That's legally effective. So I will touch on waivers in a little bit, but a waiver is only as good as how well it's drafted. So if you have a generic waiver that doesn't cover the specifics of the things that you're doing, it may not cover you, but the answer is that if you, let's say you have 10 participants, 15 participants, who cares what the number is, you can say to them, hey, I'm inviting you into my home. This is what we're going to be doing. These are the risks of participating in yoga instruction and education and classes in my home. These are the equipment that we're going to use, all of the things. Before I allow you to participate, you agree that you will release me and, it depends if you own the house or whoever owns the house, but whoever the house owner is, from all liability should any cause of action come up. So 100% you can. And what I will say as I turn it over to you, Lizzie, is just law and insurance are sort of like Batman and Robin or yin and yang, and they really work well together. Whereas the way I see it, it's like if there's a tightrope walker, insurance is the net at the bottom, like the big net at the bottom that will catch you as you're going. But then law would, like the legal documents would sort of be like a net a little bit higher up, and that hopefully it doesn't get to the point that you have to make an insurance claim, that you have to pay the deductible, because, as I mentioned, you're able to demonstrate to someone, hey, you signed this document, you have no legal cause against us. Before we allowed you onto our property, you agreed you wouldn't hold us responsible. And as such, like, you can do whatever you want, but just realize that, legally you have no position. If you come against us, we can counterclaim for damages and whatever, all this legal stuff starts. And that's usually when someone would withdraw, or they would send that to a lawyer and they would, get a legal opinion. The lawyer would say, no, because ABC happened, this waiver of liability would apply, and you've already waived those rights to bring an action against them. So from there, I'll turn it over to you, Lizzie.
Yeah, I was just gonna say, we work in unison together. We don't fight each other. So definitely, like, have your liability waivers, have all of that set up, and also have yoga insurance. In this specific case, beYogi would cover you, Laura, in the event a accident does occur. So I don't think you would need special coverage in the home. I'm not an insurance agent, so I will follow up with you specifically about that. But yes, we work in unison together. We had another question come in from Marina. She asks, and we'll answer this one question, and then we'll let Cory, maybe you wanted to finish your last little bit in the your little spiel. But Marina asks, what if the instructor is invited to give a class at a community event, a pop-up event at the park, etc.?
Okay, Marina, and I think Marina is in Texas, but I also didn't see what Marina's snack is. So if Marina feels, even if it's water, you can feel free to share that in the chat. And also, just for everyone who's listening, Lizzie was nice enough to post the online course that I made, Don't Get Sued. We made it free for everyone at beYogi because we love you guys. So if anything that I spoke about resonates or you want to learn more, feel free to go through the course for free. I think normally it's like $300, but happy to offer it for free. Okay, so Marina's question, and I can sort of segue it into the end of, or the last big thing that I want to speak about when it comes to sesame seed bar and water, okay? Sesame seeds are like sunflower seeds, sesame seeds, they're trending. I've got chia. I can't just do chia on its own, can I?
No, don't do that.
My mouth would get really dry. And yeah, so, okay, so what I'm going to do is the last thing that I sort of want to talk about in not getting sued has to do with waivers of liability. So Marina, I'm going to answer your question and then sort of transition that into talking about doing things in parks and waivers. Okay, and not getting sued. So this is how it works at law. This is like the biggest concept that you need to understand when it comes to liability. There is an automatic relationship that is established between someone who is providing instruction for an activity to someone who is receiving it. And that's called, at law, that's called a duty of care. You don't really need to know that term, but you just have to know that if you are a teacher and you're instructing someone in something, the student, you owe that student a responsibility or an obligation that they will not get injured or they will not suffer damages by virtue of participating in the class with you. So that's what it means. Now, the reason why, and now I'm going to talk about Marina's specific question. So it doesn't really, from a liability perspective, it doesn't matter if you're teaching everything in a studio or you're teaching everything online or you're teaching everything at home or you're teaching everything in a park or a pop-up or whatever it is, because that relationship, that duty of care still exists. Now, as a lawyer, I work with clients to get them waivers of liability that are specific to their business and the activities that they do and the equipment they use and the places that they hold all of these activities. So the answer is, Marina, that yes, you still are liable, even if it's in a park or even if it's at a pop-up. And it doesn't change the fact, like, let's say you're doing a pop-up, there's a really cool brand that has asked you, a brewery or some marketing company or whoever it is has asked you to come teach a class. You still are the instructor, they still are the students, and because that duty of care still exists, you're still liable to them, so that if someone gets injured, you would be liable. The space would also be liable. For example, if you do it in a park, it's possible that the municipality or the city could also be liable if there was broken glass or someone got injured and stepped on something or whatever it is. But the thing that you have to know is, and this is the big one for not getting sued, is the waiver of liability that you're using has to be specific to you and your business. So it has to name. A lot of problems I see with waivers that people copy and use is that the company is not named properly, or the person is not named properly, or like really even simple and basic things. But the waiver of liability has to cover you, and it has to explain the activities that you're doing and where you're doing and what the risks of them are. So just specifically about, if I'm doing things at a park, okay, you're doing things at a park, even if you're doing it for free, it doesn't matter because the duty of care still exists. You're still putting yourself out there to facilitate the experience for others. And let's say there's a piece of glass and someone's doing some inversion and they land on the piece of glass, God forbid, whatever it is, you're definitely going to be liable. So then the next question would be is, again, going back to the first part of what I said about don't get sued. What did the agreement say? Has someone signed properly? How does all of it work? If you have a waiver of liability that says we may be practicing outdoors or in a space where, that's unstable, you are responsible for making sure that the space is safe. Now that responsibility was on them. You told them that before you accepted the relationship in working with them. And as such, and then they release you of liability so they can't sue you. But if you're doing things at pop-ups like at breweries or other spaces, wherever it is, or you're offering classes in the park, and your waiver of liability does not explicitly mention those risks, then you would be exposed to liability as a result. And another thing that also, Marina, you just want to be sure is like, and check with your beYogi insurance agent to see where you're covered for and what you're not covered for, and make sure you have coverage that extends to all the ways that you plan to offer your services.
You see that question that came in from Laura, kind of touching on.
Yeah. So Laura, the answer is that a waiver of liability should cover all the different things you do in the different ways that you do them. So as an example, like if you go to Loss Fund and you purchase a waiver there, that will cover you for pre-recorded Zoom, online, outdoors, and in-home, and obviously in studio practice. And that's because like, other than that, we don't really see other things. Then if you're doing something else, maybe you need to work with Conscious Counsel to have it a bit more specific. But the answer is yes. And I know that there was a big issue before around pre-recorded materials or not. And so you just work with a professional who understands the industry and understands what your documents need, and make sure that it's properly covered, because remember, waivers are all about activities and risks. So the activity of you posting pre-recorded classes and someone doing it on their own, that's a different activity with different risks than even you leading a Zoom session. So I hope that answer makes sense for you, Laura.
Wonderful. I'm going to let you finish, Cory, if you have anything else, and then we'll go straight into all the questions that have come in.
I'm good.
You're good?
I feel like we've done not getting sued justice. As a quick summary, just for everyone, maybe if you're just tuning in now, the first part was all about communicating expectations in written and signed documents. That's the holistic approach to not getting sued, because if it gets to the point where you have to rely on the documents, it's already probably gone a step too far. And then the second step is having an appropriate waiver of liability or service agreement, so that someone releases you of liability, they revoke their legal right to sue you and hold you accountable. And a combination of the two will put you in a great position to succeed.
Wonderful. Yes. And if you have just joined, we've added the links to get to Don't Get Sued into the chat, so you can kind of scroll through there and you'll see it. But let's roll with the questions. And the first questions, I think, are surrounding online pre-recorded waivers and protection coverage. So the question is, I just started doing online yoga classes. How do I make sure that I'm protecting myself? I think we've covered this, but if you want to take it away, Cory.
Can you repeat the question, please?
Yeah. So they've just started her online yoga classes through Facebook Lives and things like that. How do I make sure I'm protecting myself?
Okay, so let's say you're just starting and you're at this position where you're in the process of building your everything up. The first and foremost, the thing that you need, how do you protect yourself? One, you get an insurance policy with beYogi. So you have insurance. Again, the big safety net for whatever's happening. Okay, God forbid something goes wrong. There's some crazy freak accident. You've got insurance. You know that everything's going to be okay. And then the second thing is the first document you would start with would be the waiver of liability, as I mentioned. And remember, just if the reason why that's the first one is because if you're doing Facebook Live, it doesn't really matter how it is that you're doing it. When you do it, you have a responsibility to make sure that whoever's participating does not get injured. And if they get injured and that they have not signed a waiver of liability, then technically at law, you would be held responsible for that. So the answer to the question is the first step of what you'd need would be a waiver of liability. Maybe the second step as you're growing your business, the next would be a service agreement. So that would be the relationship with your clients. Okay, what I always tell clients about service agreements, it's like, just dream that you could build, hold on one second. Lizzie, there's a code, everyone, there's a code that you can put in.
Yeah, I'll find it. You keep going.
Cool. So there's a code, don't worry, it is free, okay? Everything's gonna be okay. I'm happy that there's this voracious demand to to get into the course. But just finishing that train of thought. So how do I protect myself? I'm just starting. One, everyone signs a waiver of liability. Step two would be having a social media disclaimer and a privacy policy for a website. If you're collecting anyone's information, that's the next best thing to have. And then the third is the service agreement of the relationship that you have with your clients, and laying all of it on the table, thinking of what the ideal relationship looks like, and taking it from there. But I hope that helps. Lizzie, I will say one thing. It's like we posted the course for free and people are looking at it, but I still don't see that many snack responses. Is it possible that these people need snacks? Karen, what is your snack? Fee, what is your snack? And Christina, what is your snack? Just throw it in. Coffee. Thank you. Yo. And I'm I'm spilling some on the floor to Joe, Joe is a big coffee guy. Joe was the first person from beYogi who I met and worked with. And Joe, doesn't he love coffee? Lizzie, you can agree. You know that.
Oh, he has his coffee mug by his mouth at all times of the day.
Yeah, I remember once we had Joe on with the Conscious Counsel community, and they're all yogis like the beYogi community. And I remember he was like drinking his thing. I was talking to him about his snack. I'm like, oh, Joe, what's your snack? And he's like, I've got coffee. This is actually my 5th coffee today. And someone on the chat was like, Joe, you need to do yoga. You need to do yoga.
You all don't know Joe. Joe talks a mile a minute, and it makes sense because he has 5 cups of coffee every day. But yeah, back to that code, I did put it in. I'm going to just chat real quick because y'all are sending all your snacks. But its code is all caps beYogi to the don't get sued. Code. Yeah. We have a few more questions rolling in, and it's specifically about the topic.
Okay, I can't, Lizzie, I just have to pause you. We have to go through the different snacks that people have responded to.
Okay.
We've got organic coffee with cinnamon and turmeric. Delicious. Eating lunch, pasta. Can't lose with pasta. And fresh picked mountain apples. Delicious as well. Nuts and water, apples in the fall, watermelon in the summer, coffee in the AM. I'm ready for a t-shirt that says nuts and water, apples in the fall, watermelon in the summer, coffee in the AM. Okay, cool. We did it. And there was a question about HIPAA. So we'll get to that, but I'm going to let Lizzie take over the questions. And thank you everyone for sharing your snacks.
Yes, thank you everyone. I love the interaction with everyone. Okay, so specifically still talking about online waivers of liability and all of that. So Christina we've talked about this a little bit, but she's like, what's the liability for online classes? Like what would I be liable for if I'm doing online?
Yeah, the exact same. Remember, the duty of care exists if you're offering something online or in person. So it's not it doesn't make any difference if you are like, okay, let's say hypothetically, let's just take yoga out of it and think generally. Let's say I have a doctor and I used to always go into my doctor to see my doctor who provides diagnosis and whatever, a medical professional. So I go in and I see the doctor and the doctor says, okay, Cory, you drink coffee and you have juice and whatever. So this medication is for you and this is what you should do. I go and I take that medication. He or she misdiagnosed me. I suffer damages. I sued the doctor for malpractice, right? If I am the same thing, if me and a doctor now, because of COVID, if I'm meeting with a doctor online, we do the exact same thing, same interaction, same answers, same questions. The doctor still tells me, okay, I say, oh, well, this, I drink coffee and I drink juice. And the doctor says, okay, go get this. Misdiagnosis, malpractice. It doesn't matter if it's online or in person. What matters is the relationship established with a duty of care. And so that relationship is what will determine if there's liability or not.
Got it. Yes. And then she asked about YouTube specifically, but it's the same concept of you're liable for in person as the same as liable online.
Yeah, so but there's one little caveat for that I just want to share. So for when it comes to Instagram Live or Facebook Live or YouTube, it's a little bit different. So a waiver of liability is used when you're able, to control who is participating in the activity. So I'm a yoga teacher. I have a Zoom room, and in my Zoom room, I only allow people in who I know have signed a waiver of liability. I'm able to control that. So I say, okay, before I'm letting you in the room, and think about it, it used to be physically in a studio. Before you're allowed past the front desk and into the studio, you have to sign this document. Because Instagram Live, anyone can join at any time, because Facebook Live, anyone can join at any time, and because YouTube, anyone can watch it from anywhere at any time, you're not able to use a waiver of liability because you can't control who's accessing it or when they're accessing it. So the best solution for YouTube is something called a YouTube disclaimer, which lives on your channel, and it's a text that you post at the bottom of all of your videos that says, won't do it at your own risk, and these are my qualifications, and consult a medical professional, and all of the legal jargon that needs to be included. But that's the best thing that you can do. But YouTube's different because Instagram Live and Facebook Live, you don't have that opportunity of it being fixed in a place that allows for text, whereas in YouTube you have that.
Talking about disclaimers and YouTube disclaimer, this is kind of just a question that I just came up with, but talk about a little about the social media disclaimers. Can't you add that to potentially the caption maybe? I don't know.
Yeah, you could. And I spoke with a client today who has a podcast, and the question that they had was about, how do I include a disclaimer in my podcast? And their question was, do I have to share every time, at the start of every podcast, oh, this isn't, professional information, and consult a doctor before you do whatever, all the stuff that no one really wants to say. And with social media, the feedback that I get from most of my clients is like, they don't really want to put something out there. Like, they want their text to be, I don't know, eagle pose, how amazing is it? Or Shavasana, OMG, hashtag beYogi, right? Whatever it is that they're going to write. So it's not really that sexy if you're writing something with captions to have legal text. The best that you can do for social media is have a social media disclaimer that's connected to your website, or that's part of your link tree on your profile. And that's the answer.
Awesome. All right, let me pull up the questions.
Also, while you're pulling up the questions, I want to share with everyone, I just got back from a week in the Amazon, and this is a crocodile tooth. Part of the visit is you go visit a local community, and they have a gift shop. A gift shop is a very generous term for what it is, but part of what they sell is crocodile teeth, and I got one. And if anyone wants to share on the message board any cool random object that they have that they sometimes hold when they're doing webinars, I'm open to listening to that.
Oh gosh, I love it. Okay, so can you outline, so someone asked another question about liabilities. Can you outline, so I know we've done a webinar about this. There's like 5 things to a liability waiver.
Yeah.
Right? Can you outline those 5 things?
I definitely can. So we call them elements to a waiver of liability. And this is like, look, this is just a great way to think about it for whatever you're doing. And if you feel confident in writing your own waiver, then these are the things that you'd want to check it against. And I think we have a free legal checklist as well, in addition to the course, so that like you have a roadmap. But so the first thing is always going to be, what are the activities? So what are we doing? How are we doing it? Where are we doing it? What equipment are we using while we're doing it? And the reason why activities are so important is because if you do not include something in your activities and someone gets injured doing that, they could say, you're right. I agreed that, for Ashtanga or flow, or for yin, or for whatever it is, that I was, Iyengar chair yoga, that I would not hold you responsible. but you know, we were doing acro in class, and you didn't explain to me that the risks of acro were different. And if I knew we were doing acro, I never would have signed the agreement. So the activities, you want to make sure that you cover all the different types of ways and ways that you do yoga. In addition to that, this is where you want to put like online, in person, in a park, all of the different ways that you offer it. And then you also want to include COVID if you offer things in person. This is like where a lot of the COVID stuff goes. Okay, so that's a lovely comment. Thank you, Karen. And so, okay, so first is activities. The second is the risks. Cool, this is what we're doing, and this is how we're doing it, and this is the equipment we're using, blah, blah, blah. Risk is like, how can go wrong? How can it go wrong? It can go wrong because, you know, you could fall, you could slip, you could fall on your head, you could have a migraine, you could be dehydrated, whatever, all the different, you could catch a communicable disease, whatever it is, all the things, those are the risks of the activity. So number one is, what are the activities? Number two is, what are the risks? Number three is, what are the outcomes of the risks? So the outcomes of the risks is like, okay, what is an outcome of falling on your head and having a concussion? It could, you know, lead to significant, change quality of living. You may not be able to carry out work as you were doing before. And also ultimately it could lead to death, which is like, I'm a life guy. I like life. I'm having a lot of fun being alive, but accidents can happen anywhere. Anyone could have a heart attack in any particular instance. So if they have a heart attack while they are in your duty of care, you'd want something to specifically address that. So summarizing the first three, what are the activities? What are the risks? What are the outcomes of the risks? Number four is, having shared all that information with someone, they voluntarily choose to participate. So cool, you told me what's up, what can happen, how that can affect me. I voluntarily choose to participate. No one's making me do this. Number five would be affirmation of health. So you told me everything that we're doing and all the ways that we're doing it. I'm healthy enough to do it. It's my responsibility to ensure my own health before participating, all that stuff. And then the sixth element is finally, it's like the release of liability. So, hey, cool, I've told you 1 to 5 is covered, having all of that super crystal clear. And as a result, I will not hold you liable for any of this stuff. And before you allow me to participate with you, I agree that I will not hold you legally responsible as the activities take place. And that's
awesome.
And there should be an accompanying dance to the 6 elements, don't you think?
I agree. Maybe we'll do that for the next webinar.
Yeah, for good old number 5.
Number 5. Oh, maybe it should be on number 6. All right. Okay, so Laura asked, and this will be our last question specifically about liability waivers, but she asked, so Cory's platform will have all of these different items available. Is this correct?
Yeah, so I can put the link to Law is Fun here. Again, remember, we're still in soft launch phase. Yeah. But also as a result, everything's 50% off. And it was closed before, but I just reopened it because I knew that we were doing this beYogi webinar. So all of the 3 main documents that I've discussed today, all of them are available there through lawsfun.com. Wonderful.
Alrighty, so moving on. I have a question specifically about trademarks.
Yeah.
So they said they've just started their yoga business. They have the concept. How do I start the process of, trademarks and copyright and all of that?
Yeah, the first thing that you're going to want to do is get a seatbelt. It's going to be a wild ride. It's going to be a wild ride. It doesn't necessarily have to be, but I also want to just introduce everybody to my puppy Lua. Because I saw that Christina's holding her dog. I wish I could see Christina. This is Lua. Lua means moon in Portuguese. We're coming up to full moon, aren't we? I feel like it's nearly here. Precious, exactly. Oh, bebezinho. Oh, amor. Oh, meu bem. That's it. No more talking to the dog. Okay, so look, the way that if you want to start the process, if you want to do the trademark totally on your own, which you can, you go to uspto.gov. You can do a quick search to see if the mark is registered, and then you can try to register it on your own. registering trademarks is a very complex activity to do, but the answer, and I'll just type it here for everyone. This would be the starting point for you to go if you wanted to register a trademark. You'll see it's a little bit overwhelming. Often, I would say, like, the trademark work that we do at Conscious Counsel is divided into two. One is the, like, 50% of it is going to be clients who already tried to do it on their own and it didn't work, and then they hire us to do it for them. Or the second half are people who are like, hey, I know that I need this and I know that I want it done, so please do it for me. The one thing that I would just say about trademarks, it's a really, really important thing to do to protect your brand and to protect your goodwill and everything that you're creating. But just make sure that you're married to your logo or business name or slogan or whatever it is that you want to trademark. Like, the level should be married. If you like it, then you better put a ring on it. If you like it, then you better register it for a trademark. It's like being married. So if you're like testing the name out with a couple, I would say that's not the right time. But the moment that you know that that's your brand, your name, your slogan, your logo, whatever it is, that's the right time to trademark.
Gotcha. Thank you. So, question on that. So someone that has just started, you wouldn't necessarily say, all right, it's time to go get a trademark. You would say, test it out for a little bit, unless they're like married, right?
No, like, I'll tell my story. So with Conscious Counsel, I registered the trademark before I ever had a client, just because I knew it was like, I knew Conscious Counsel is the name. Same with Law is Fun. Like, I registered the trademark for Law is Fun maybe a year ago, just because I knew it. I'm like, I'm building this around Law is Fun. That's what it is. So I'm going for it. The same with my law firm, Conscious Counsel. I was like, I love the name Conscious Counsel. I know this is what I'm going to do for the next while. So I'm sticking with that particular mark. So it's less of, if you're just starting, or even if you haven't started, it doesn't matter. But what matters more is that you know that that's what you're going to build your business around. And the moment you know that, that's the moment to register the trademark.
Got it. So if anyone has any specific questions about that, definitely add them to the chat. All right, so we'll move on. So this question was about being a subcontractor for, a yoga studio. They were kind of just asking questions about, what are my rights as, a part-time employee of this studio.
Yeah, there's a lot to unpack there, and a lot of it is jurisdictionally based. So the three major agreements that I speak about are less jurisdictional, like there's less jurisdictional issues around them, whereas independent contractor and what actually makes an independent contractor is based much more on a state-by-state basis. So if that person's there, we can ask them what state they're in, and I could chat about it. But the other thing to know is that a lot of studios will try to over-enforce rules against contractors. And really, like, if you look at what the test according to the IRS is regarding classification of an employee or contractor, typically what happens is a studio will call someone a contractor but treat them like an employee. So what I would say is, if someone's curious about what their rights are, like, take half an hour and do a bit of research and understand in your state what the test is and what your rights are. And the issue that always comes up is non-competes and non-competitions. And that just it always comes up in a sense that studios are always trying to restrict teachers of their studio to work with anyone else. But it's an inherent contradiction to have a contractor and a non-compete. That's like in nature of itself, it contradicts itself. But a lot of studios will just try it and try to get away with it and try to scare people by saying, oh, well, you sign this and this is what it says. And with everything, the sooner that you can become legally informed and understand your legal position, the better you'll be, and the more clarity you'll actually have into understanding what your rights are.
Got it. She or he is not around. They sent it to me via email, but we'll add some information to the blog and to the email that we'll be sending tomorrow about this.
Super.
Just the recap. All right. So this one's about LLCs. She asks, does the creation of an LLC shield my personal assets if I am the only one in my yoga teacher business?
Yes. The answer is yes. So the way that an LLC works is it's the creation of a separate legal entity. And so long as all of the relationships are entered into on behalf of that LLC, then it doesn't matter if you're the only member of the LLC, that's irrelevant. What matters is that so long as people are contracting with the LLC and not with you personally, then the LLC is liable to the extent of the assets that are contained within the LLC, and personal assets would not be accessible, because even though you're a member or an officer or director of the LLC, it's a separate legal entity, so you're not personally connected to it.
Got it. Cool. So this question, I did want to focus some time on COVID and having to, update your liability waivers with that information, because studios are opening back up. Places are basically open in most states in the US anyway. So I did want to touch on adding that back or into the liability waiver and that all stuff about COVID.
Yeah, so it's anything related to vaccines. If anyone has any vaccine questions, feel free to ask them. But basically with COVID, look, how it plays in is a couple of ways. One way, as I mentioned in the liability waiver, the activity. So the activity is if you're offering in-person services, or you're a studio that's open and people are coming into your space, or you're having people in your home, the reality is there still is a communicable disease going around. And therefore, the risk of doing things in person is different than it was before COVID happened. And so the waiver should explicitly mention that. The other ways that we see sort of like COVID sort of creeping in has a lot to do with service agreements. So for example, in a service agreement, and because sometimes you may have to, like certain things that have happened with studios is, being forced to close as a result of COVID. If there's a reported case, maybe there's a period where they have to be closed, or they have to send all this information. Maybe you have reduced capacity compared to what you had before. Maybe there's going to be a period where you shut down the physical space and then offer things online. And what I always say to clients with your legal documents, you want your documents to reflect the most recent version of the relationship that you have with your clients. So more of what has changed about COVID, and again, like if we just take vaccines as an example, there's a wide spectrum of different professionals who have different perspectives on what their vaccine policy is or should be, in conjunction with whatever local government rules or laws there are. So the most important thing when it comes to COVID is like, just think like, okay, now COVID's changed things because, maybe with my employees, in the event that someone tests positive or is at risk, was connected to someone who had it, this is our policy in our employee handbook that should be included. When it comes to the services with your clients, okay, if we suddenly have to shut down or we have to cancel, this is what's going to happen. If we only have reduced number, this is how our reservation system works. If you're having any symptoms, you're not allowed to come in, and we'll hold you responsible if you do come in. And same sort of with vaccine stuff. If you have a space where you determine that only vaccinated people are permitted, then you have to put that as part of the agreement, and that, people legally are making a promise that they've been vaccinated, and that if they make a misrepresentation or they lie, that they would be responsible for any damages that they cause as a result. So it sort of like seeps into everywhere. And instead of focusing so much on just COVID, I just always go for the general approach, going general of, okay, how have my relationships changed? How do I now offer my services? How is that different from before? And making sure all of that's in the documents.
Gotcha. Yeah, if anyone here has any questions about that specifically and about vaccines and all that, I know that is a topic. Feel free to ask them. Feel free to say, what should I do? All right, so we'll keep it going.
Yeah, we're going to keep this party going. Does it feel like a party for everyone?
Well, now that, yes.
Yeah. I'm like, this is like Saturday night for me. This is better than Saturday night.
Yeah, law is fun. Makes sense.
isn't it though?
All right. So if I'm a private yoga instructor operating out of a fitness studio as an independent contractor, do I need a waiver of liability in addition to the one the studio has?
Yeah, look, the only way that this is how the answer would be no. I would say no, you do not. If that studio has a kick-ass waiver of liability that covers yoga and the yoga teachers who teach there. That's the answer. The chances of that being a reality, I would say, are quite low. And I say that just based on my experience of like, people will always send me waivers, and 1 out of 30 times I'll be like, yeah, this is good enough. Awesome. Great job. So what you'd want to do in an ideal scenario is have your own liability waiver for anyone who you practice with. And like, look, if people think that's weird, you just have to explain to them, like, I'm assuming all risk by providing these activities to you, and I'm happy to do so, and I want things to be awesome, and I want you to touch your toes or be flexible or be mindful or whatever the, part of the goals of whatever it is, the intention of your class. But if that gym, like, let's say as an example, that gym has a waiver of liability that only covers fitness, it's not going to help you. Yoga is a different activity. I even gave that example when I was going through the different elements. Let's run through the situation, how I've seen this happen. Someone goes to the gym, they sign the waiver of liability. It's probably a crappy waiver of liability, although I'd love to believe that it's a great one. And it's all the fitness things. So it's TRX, and it's kettlebells, and it's battle ropes, and it's treadmills, and it's Stairmaster, and blah, 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 and spin classes and HIIT. And it doesn't mention yoga. You're offering yoga at that particular studio or that gym. Someone gets injured, really hurts themselves, is unable to go to work, sues the gym, holds you responsible, sues you. The gym's going to say, oh, well, they signed a waiver. The person's going to say, or the person's lawyer is going to say, because the lawyer is going to look at the valuation of how much money they can win by pursuing the matter. That's the reality of how all of this works. They're going to say, oh, well, you mentioned TRX, you mentioned Stairmaster, you mentioned cycling classes, you mentioned weight activities, but you didn't mention yoga. So the understanding is that you intentionally left that out. And as such, my client never agreed to release you from anything related to yoga activities. Therefore, their right to bring an action against you is still fully alive and exists, and, pay us the $47,000, whatever it is.
Thank you. I never know what to say right after. I'm like, that was a great explanation and good job, Cory.
That's very kind of you. It's all good.
All right. So we hit all the questions that I got specifically emailed to me. So
there's one from Marina. I want to make sure I get to Marina's.
Yes.
Marina said, can you repeat the privacy policy? Reminds me of HIPAA. Also, what am I responsible for protecting payment info taken electronically? Great. So Marina, we're delving into the world of privacy policies here. HIPAA most likely will not apply to what you do as a yoga teacher. And that is because HIPAA is specifically designed for professionals who either provide medical services or who are referred to by other medical professionals as part of their insurance program. And it's all about the keeping of medical records. That's basically what HIPAA is about. If you're a yoga teacher and people are coming to you and they're getting memberships and they work one-on-one or whatever it is, HIPAA will not apply. Privacy policies do apply, and privacy policies will apply. So one of the rules about privacy policies is okay, if you are collecting information or facilitating the collection of information for anyone who you work with, you have to have a privacy policy and we have them on Laws Fund, that specifically outlines okay, what information is being collected and how do we store that information? Are we sharing it with third parties? So the answer specifically to the what am I responsible for protecting payment taken electronically? Technically, you're responsible to share any third party that you use in processing that particular transaction. So if you work with Stripe or if you work with PayPal, you'd have to include the privacy policies of those third-party platforms who collect that information. At law, that is your particular obligation. And then Laura says, HIPAA, if you are a nurse who provides yoga, does that change anything to your response? Okay, if you're a nurse, it's all like, here's an example where, in my understanding, how HIPAA would apply. You're a nurse who offers yoga. The first question is, are you a yoga teacher who's also a nurse, or are you a nurse who also provides yoga? And that's just important because if you're a yoga teacher who also happens to be a nurse, then likely HIPAA won't apply. I'm a lawyer and I'm also a yoga teacher, but when I'm teaching yoga, I'm not doing anything like I'm not providing legal advice while I'm teaching yoga. I'm just teaching yoga. But the big distinction from all the research that I've done on HIPAA is that if someone, let's say someone's been in an accident and part of their recovery that they're doing or part of their treatment for something that they're going through is having a nurse guide them through a yoga practice, and let's say their insurance company or their medical health coverage is paying for that particular yoga class, then the answer would be yes, HIPAA would apply in that context. But if you're a yoga teacher who also happens to be a nurse, then it doesn't really matter because anyone can be anything, but the question is, who are you providing the services as? And I hope that helps.
Great. I'm not sure. So I think Laura or Marina just asked that. She said, I'm an occupational therapy assistant, but won't represent. Oh, she's just explaining. Okay.
Yeah.
Wonderful.
So I think we're at the end. And just to touch on that final point, I have a lot of clients who are like naturopaths or doctors or all these other things. And then they start other projects and we make it very, very clear on the documents, like, any other qualifications outside of what I'm doing as a yoga teacher are not relevant. See medical professional, all that sort of stuff. So as we wrap up, the only thing for me is I'm just going to put the 2 links in there again so that everyone has them. One is to Lost Fun. I'm going to find the online course and put the code. But Lizzie, anything else from you?
I'm just going to say we will follow up tomorrow with this information plus the 2 links that Cory just added in with the code, so you guys can get access to that free course. And thank you, Cory, for doing that. He also just added his email in there to be able to email him. But we will send in the follow-up a link to this webinar so you can rewatch, send it to your friends. Yeah, we enjoyed this so much. Thank you all for attending. And we hope to see you all next time. Thank you, Cory.
Thanks for having me, Lizzie. What a pleasure to meet everybody. I'm happy about these snacks. Keep snacking. Like whatever you do, just keep snacking, keep the good vibes, keep putting good things in your body that are helpful and make you happy. And I promise you that I'll do the same. So nice to meet everyone. Look forward to supporting you. Lizzie, thanks so much. My love to everyone at beYogi. Thanks for having me.
Talk soon. Bye-bye.
Bye, guys.